we have, I know that we have press participation here, and for those on this call who are presenting, just an FYI, it appears we have Aaron Moselle from WHYY, Claudia Lauer. I see Yoni Brook on the cell. That seems to be what I am seeing. Let me just go ahead. All right. So the run of show here will be that I will speak. I'll turn it over to Miriam Krinsky, our good friend and ally and expert on all things prosecutorial from FGP. And we will then turn it over to brilliant staff of the law division, two of whom are here. And then we'll go to questions. Let me just start out, if I may, by saying that the Philadelphia District Attorney's Office today, in addition to fair and just prosecution, and we expect there to be another brief as well, filed briefs today. The DA's brief, of course, was the usual one. Fair and just prosecution's brief is what is called an amicus brief, a brief that supports the position that the DA's office is taking. And then we also understand there may be another brief being filed by another organization also supporting the position of the DA's office with reference to a matter that is very much of the day and very important. Simply put, it is this. In the case of Commonwealth of Pennsylvania versus Ryan Pownall, a case that involves the killing by police in uniform and on duty of a man who was unarmed and was running away at the time he was shot. We are contending that Pennsylvania law violates the Constitution, in that it essentially says that police can do things, and in fact, they can kill people by doing things that are unconstitutional, according to the US Supreme Court. That's a problem. It seems to us there has to be one standard of justice, which is under the Constitution. A prosecutor's oath in Pennsylvania includes two main things: one, to seek justice, but number two, to uphold the Constitution. And it would be inconsistent with my obligation to uphold the Constitution to go to trial in a case where a defendant police officer is going to say, yeah, but it's okay because I did something unconstitutional and that makes me not guilty. We cannot have state law that encourages and incentivizes police officers to violate the Constitution while they are killing people. We cannot have that. And for that reason, we have taken the step of filing an appeal before the trial of Ryan Pownall so that we can have a trial that is fair. I am extremely grateful for the excellent legal work that has been done by our team, and they will speak on this in a moment, but I'm also extremely grateful to Fair and Just Prosecution for an excellent amicus brief, actually written by attorneys from Hangley, Aronchik, Siegel, Pudlin, and Schiller, a Philadelphia law firm, but heavily supported by Fair and Just Prosecution. For those of you who do not know, this organization is headed by Miriam Krinsky, who will speak next. Miriam Krinsky is a former federal prosecutor with a very distinguished career in criminal justice, who in recent years has been the executive director of Fair and Just Prosecution. It is in many ways the leading organization in the United States for progressive criminal justice, especially in terms of progressive prosecutors. There are 68 signatories on this brief. I won't go into detail because I know that Miriam Krinsky may want to, but those signatories include attorneys general, they include prosecutors from all over the country, they include chiefs of police and other experts in policing who believe, just in the same way many progressive prosecutors do, and just in the same way that most people in the United States do, that there has to be limits on police conduct under the Constitution and that there has to be accountability for police in our government. We will be taking questions at the end, but at this point, I'm proud to turn it over to Miriam Krinsky for a few comments, and then it will be turned over to representatives of our law division, starting with Nancy Winkleman.
Thanks so much, Larry, and thank you for acknowledging the tremendous work on this brief by the Hangley firm And I also want to acknowledge David Weiss and Layla Robbins and Alyssa Kress and others from the Fair and Just Prosecution team. Let me start by referencing what the brief itself says. And with the voices of 68 national leaders, elected prosecutors, a number of attorneys general, over a dozen law enforcement leaders, current and former police chiefs and sheriffs, head of national policing organizations, what they've come together to say in this friend of the court amicus brief. As they say, the issues in this case raise national significance. And because of that, amici come from jurisdictions across the country. We share a steadfast belief in the starting point that police are not legally permitted to use deadly force beyond the boundaries the US Supreme Court has established. Any lesser standard not only contravenes federal constitutional laws, it fails to promote accountability. As the brief says, the question here, though expansive in its implication, is actually narrow in scope. There may be no more important task for prosecutors and criminal justice leaders than seeking justice when a person's life has been taken. We know after the very unusual year plus that we've been through that there is a crisis of confidence in policing in our systems of government. And this is a dire time when accountability needs to be stood up. And we simply can't erode the notion that police who shoot unarmed individuals in the back have to be held accountable. And any interpretation of the law that doesn't do that is not only at odds with the Constitution, but it further erodes trust. And by virtue of that, as these leaders have come together and said, it makes all of us less safe. So because of that, there are going to be many eyes on this case. The statute at issue is one that we see as well in other parts of the country. And this is a case that has national implications. These leaders have come together to make clear that without trust in policing, without trust in the system that holds them accountable when they cross the lines of the law, without trust in our criminal legal system, we simply cannot ensure public safety. And because of that, at issue in this case is whether the Pennsylvania law is going to erode that trust or is going to fortify that trust, whether Pennsylvania law will hold police who use deadly force accountable, or whether it enables them to construct a defense that is at odds with what the Supreme Court has told us needs to be the line in the sand that our law draws. So far in 2021 alone, 440 people were shot and killed by the police. In Philadelphia, before this case was filed, more than 1,000 police shootings had occurred over a 20-year period without a single police officer having faced criminal charges. So we applaud Larry, you, your office, your colleagues for trying to move forward with this case, for ensuring that the law will hold future police officers accountable, and are pleased to be joining with this amicus brief and bringing our voice to a vitally important issue, not simply for the city of Philadelphia, but for our entire nation.
Thank you, Miriam. It is also my pleasure to introduce Nancy Winkleman and Matt Davis, both of whom are in our law division. Nancy is the chief of our law division at the district attorney's office, supervising staff of, I would say, 50 to 60 attorneys at any given time. And Matt is one of her young charges who has done yeoman's work and come up with some pretty brilliant reasoning and arguments for a brief. So first of all, it is my honor to introduce Nancy. I'll let her introduce Matt.
Good afternoon, everybody. We are delighted that this moment has come. The Law Division works on post-conviction and appellate matters for the District Attorney's Office. We are so proud to be able to serve the DA and the City of Philadelphia on this case. The legal issues in the case, for those of you who have taken a look at our 51-page brief, get pretty wonky pretty quickly. So I'm going to try just in a couple minutes to give a very broad brush overview. As Miriam said, the US Supreme Court has made clear that law enforcement can use deadly force only when it's necessary to prevent death or serious bodily injury. The reason that we took a pretrial appeal in the Ryan Pownell matter was to ensure that the jury that would be instructed in this case would be instructed in compliance with the Constitution. And specifically that Officer Pownell was justified in using deadly force only if the jury were to find that the victim, Mr. Jones, presented a risk of death or serious bodily injury. The statute is long and it's complicated. It's section 508 of Pennsylvania statutes. The full site is in our brief. There's a question in that statute of whether in fact it limits police officers' use of deadly force to situations that would comply with a person's constitutional rights as set forth by the US Supreme Court. But, and this is a really important but, there's a way to interpret the statute to comport with constitutional rights. And as we set forth in our brief, that's what we urge the Pennsylvania Supreme Court to do, to construe the statute in a way that is in compliance with the United States Constitution. The wonkiness of this is that there are a few wonky pieces. One is when we get to the merits of our constitutional argument, there's this whole thing about whether the word or can be interpreted conjunctively. And due to the really brilliant research and work of my colleague, Matt Davis, we have strong precedent that it can be. Courts are obligated to construe a statute to comport with the Constitution if they can, and they can here. And our brief gives the court the roadmap. The other wonky part of this, and for those of you who have looked at the brief, it's the first 20 or so pages, is that there's a threshold appellate jurisdictional issue. And I'm not going to get into it because it's not what the case is. It's not the core of the case, but there is a jurisdictional issue that the court will have to reach first because we have taken this appeal in a pretrial status, and there's special hoops that an appellant has to jump through in order for an appellate court to exercise appellate jurisdiction over pretrial matters. I'm going to leave it to that. I will let Matt Davis add as he wants without getting too much into the weeds, because it's quick to get into the weeds. I want to say again, Matt's a young lawyer in the law division. He joined us in 2018. Among our many stars in the Philadelphia DAO law division, Matt is certainly one of them. And for a young lawyer, has poured his heart and soul into this matter. So Matt, I don't know if you want to add anything at a high level, if we can.
Thanks, Nancy. Yeah, I think you did a good job of giving the overview of why this is really important. I don't want to get too into the legal specifics and bore everyone, but basically exactly like you said, we have a statute here that gives police officers a justification outside of the bounds of what the United States Supreme Court has said is constitutionally reasonable. The statute would let police officers use deadly force against all forcible felons and anyone who is fleeing with a deadly weapon, which is way too specific and does not comply with the Constitution's requirement that everyone who is the recipient of deadly force poses an actual present danger to the officer or others. So we tried to make an argument that the court is bound to interpret that statute in a different way, basically by stringing those requirements together as one conjunctive requirement. And that's something that courts are routinely called on to do and asked to do, is to interpret legislation. And that's one of the duties of the judiciary is to do that. So we hope that the Supreme Court will exercise that duty. And that's basically it. I'm happy to answer any more specific questions that anyone might have.
All right, thank you, Matt. So at this point, if there are any questions from the press, I would ask you to please put them in the chat, and then I will read them out, maybe even divvy them up. If you are seeking an answer from a particular participant here, you can note that, but otherwise, we will try to answer any questions that appear in the chat. And now as the suspense builds, let me just say that if there are no questions, no doubt due to this tremendous downpour we are experiencing here in the usually fair-skied Philadelphia, then we can all run for our umbrellas. But I'll wait a minute just to see if there are some questions. All right, we do have a question from Aaron Moselle from WHYY, and this question is to all of us. Will this decision, if it goes your way, be applicable to Pownall retroactively? I'm going to provide that to my law division to answer. Nancy, I'll let you figure out which one or both of you should answer that.
Sure, I'm happy to briefly answer it, and you can find the detail of that in our brief starting on page 41. For those of you who want to wait till the rain leaves, for those in Philadelphia, and read our brief in the meantime while the storm passes. We did face the argument in the trial court, and this case also has had a little brief visit to the Intermediate Appellate Court in Pennsylvania, the Pennsylvania Superior Court, that construing the statute as we argue it needs to be construed, it must be construed, would violate Officer Pownall's due process rights, because he would not have been aware of that, this different construction, this new construction, at the time he committed the act in question. As we explain in our brief, and I really would like our brief to speak for itself too, but as we explain, for one thing, there's a legal argument why that's incorrect, why judicial decisions are not subject to the ex post facto clause. But there's also a very practical argument. There was a Philadelphia Police Department directive, which we quote in our brief, that Officer Pownall was trained on, or at least it was in effect. He should have been trained on it. It was in effect at the time. It was issued almost 2 years prior to the acts in this case. That says, actually, it says exactly what we argue the statute has to be interpreted as saying, which is police officers shall not use deadly force against another person unless they have an objectively reasonable belief that they must protect themselves or another person from death or serious bodily injury. That's the US Supreme Court's requirement of when a police can use deadly force and comply with the Constitution. So Officer Pownall had notice. There is no due process issue. There's no ex post facto issue. He was trained in compliance with the Constitution.
Thank you, Nancy. I would also note the Tennessee versus Garner, a case that is cited in these briefs. A famous United States Supreme Court case that directly addresses these issues was decided in 1985. It was news to no one that the Pennsylvania statute, which to some extent says police officer, do what you want, is out of compliance with United States Supreme Court rulings that have interpreted the Constitution. Are there any other questions from media? Okay. All right. So I'll just close out at the moment, and if a question shows up, we will address it. But let me close out making a point that I think was made extremely well in both of these briefs that goes to broader policy considerations. And that is at a time when offices like mine and police departments like ours are struggling to be able to solve shootings and solve homicides. And we find over and over and over again that there are no witnesses, civilian witnesses, willing to come forward and provide information to police investigators, that many of them are not even trusting enough of prosecutors to come to court at a time when this is a huge hurdle in terms of public safety in solving unsolved shootings and unsolved homicides. The issue fundamentally is one of trust. The relationship between policing and communities has been harmed severely by a lot of very negative policies going back decades, only a couple of which include illegal stop and frisk and mass incarceration among police, and then among prosecutors, some pretty dirty tactics that frankly involve lying, cheating, and stealing to convict people at all costs, including some people who are innocent. And so when we do things at the Philadelphia DA's office or any other prosecutor's office, like exonerate people, it builds trust that is necessary to get those witnesses in the future. And when we do things like challenge a state law that effectively says to police officers, kill them if you want, in violation of the United States Constitution's specific requirements. Once again, what we are doing here is bigger than this one important case. What we are doing here is we are rebuilding trust. We are making it so that public safety is enhanced because trust in law enforcement is restored. And we are very proud to do that. All right, we do have another question from Claudia Lauer of the AP. She asks, do you have any idea of how many other states have the fleeing felon laws? I'm going to leave that question either to Miriam or my law division or all of you. Would anyone like to address that? And if the answer is no, we can say that too.
Matt, do you have that in front of you? Or I don't want to put you on the spot because I don't have the number.
Yeah, I can maybe from the great research that I know, Matt, you and others there did, or Matt, if you want to chime in either way, I know that it's my understanding that 18 states, including Pennsylvania, have statutorily permitted the use of force where the suspect has committed a violent felony and is escaping or is likely to endanger life if not arrested. But 19 states have codified the common law rule permitting deadly force against all fleeing suspects. And then there's some other categories. I don't know, Matt, if you want to add to that. I will note that the number of states that this case will impact was part of the reason why many of the leaders who signed on to this brief, in addition to the general principles that DA Krasner referenced, but clearly this is not a case that that will only impact Pennsylvania. Other states, I'm sure, will be watching, and they may well choose to go a different direction depending on what the Pennsylvania Supreme Court does. But the issue here is one that's fundamental, and it's one that other states are going to have to grapple with in their own right, but that leaders around the country believe is significant enough that the ripple effects are going to be important, and that, as mentioned earlier, many eyes will be on this case.
Yep. Thank you, Miriam. I think you're about right with that number. Without wanting to put a firm number on it, I think it's around 20 states that have a similar justification to Pennsylvania. And the reason for that seems to be that these laws are so infrequently challenged that nothing has really happened to precipitate a change to that. In my research, it seemed like that construction of a statute came from an old model penal code rule or something like that, and states just sort of went with it, and it sat there until now. So we are hoping that a decision here could potentially start to move those laws in a different direction.
Let me maybe add another piece to that, and I'm sure, Larry, you may well have thoughts on this as well. Sometimes how we interpret the law becomes an issue. Sometimes how we interpret the law becomes an issue in a particular case after it's charged, but also how the law gets interpreted is symbolic. It's an important message to the community of what our standards are and what, as I referenced earlier, what line in the sand we're going to draw. And it also is a message to prosecutors as to whether or not they should proceed forward with attempting to pursue a case. And these are not easy cases to prosecute. And unfortunately, it has been the rare exception rather than the rule where prosecutors have tried to hold police accountable. In my decade and a half as a federal prosecutor, most of it in Los Angeles, I did see attempts to pursue these cases. They are hard to bring, they're hard to win. And so if the law becomes yet another hurdle or steep ascent that prosecutors have to overcome, then we're going to continue to see the prosecution accountability of police officers as the rare situation, which continues to erode that confidence in our community that the justice system can get it right. So what happens in this case, both is applicable as a legal standard to future cases, but it's also very much of a strong indication to future prosecutors and to communities as to whether or not holding police accountable is going to be possible under our criminal legal system.
Right. Thank you very much for that. We do have another question from the press, and this is from Ashley Caldwell. The question is the rule for officers not to chase individuals on dirt bikes and the likes a reaction to this case? And do you know if City Council, meaning Philadelphia City Council's recent bill making those vehicles illegal is a reaction to this case? I can field that one. These issues are not the same. I think we all recognize that there's a difference between a police officer in uniform who points a gun at the back of someone who's running away, aims, pulls the trigger, and then does it more than once. That is obviously a very intentional infliction of harm. And the question in that case, if that officer is tried, as is happening in the Pownall case, the question is going to be whether or not that deliberate intent to harm is justified, whether it meets a legal standard that makes it okay to have done that thing that would otherwise be a crime. The situation that has arisen over decades with high-speed chases on highways involving cars and buses and motorcycles on occasion, the situation that is at issue in Philadelphia, where we have ATVs and dirt bikes that are running up and down Broad Street and in various other locations, sometimes doing things that are illegal, is not an issue of police officers trying to ram those vehicles or run over those drivers. It's an issue of an attempt to pursue them, but an attempt that we know from years of data places all of us in more danger, including babies and strollers and mothers pushing those strollers as they walk down the street. It places all of us in more danger than allowing the person who is being pursued to get away temporarily and to be apprehended in another way. So while they raised a couple of similar issues, this litigation, this case law, in my opinion, has nothing to do with City Council's recent efforts to solve a problem that is a great challenge for the Philadelphia police. And in fairness to them, bad enough to chase a car, but when you're chasing a vehicle that can literally ride over your car, should you make a roadblock, that can go up on sidewalks, when you're facing the prospect of pursuit and roadblocks where they can go around, and by going around would endanger anybody on the sidewalk, you have a difficult predicament. So the short answer is no, they're really not connected, but obviously I see why that is an interesting and thoughtful question. Are there any other questions from the press? There being none, I wish you all a wonderful evening. I hope you have an umbrella in Philly anyway. Thank you very much.